Late one night in May 1997, Coffs Harbour, Australia. You know how sometimes the air just feels charged outside a nightclub?
Yeah, end of the night, maybe a few too many drinks.
Exactly. And something really small, like a simple $20 bet about getting one last drink, it just exploded, spiraled into violence.
And not just a minor scuffle either. It turned into a really brutal robbery.
Yeah, you had two young guys, Matthew Hunter and Troy Sarah, and a local man, Raymond Forbes, suddenly caught right in the middle of it all.
So police get called, arrests are made, the usual process, and the case goes to trial.
And at first glance, it looked like justice was served. Both Hunter and Sarah were convicted. You'd think, okay, story over, crime, trial, conviction, done.
But as you always say, it's rarely that simple, is it?
Never, because what happened after that conviction, that's where this case, RV Hunter and Sarah, gets, well,
Yeah.
fascinating and, frankly, pretty disturbing.
It really shifts focus, doesn't it? From the crime itself to what happened inside the courtroom.
Totally. This isn't just true crime. It's a deep dive into the legal process itself. The choices, or maybe the lack of choices made by the defense lawyer, became the absolute core issue.
And it led to this stunning reversal on appeal. A decision that's now, well, it's become a major cautionary tale in Australian law. Kind of uncomfortable, but crucial.
It's one of those cases where the courtroom strategy, the lawyer's actions, become just as important as what happened in that alleyway. The whole legal profession's ethics and competence ended up under the microscope right alongside the accused.
So our mission here in this deep dive is to walk you through the whole journey of RV Hunter and Sarah. We're starting in that dark alley in Coffs Harbour.
Right, then through the district court trial where things went so spectacularly wrong.
And finally, into the New South Wales Court of Criminal Appeal in Sydney, where the system itself had to confront its own failings.
We're going to unpack everything, the incident, the legal steps, the key players, and really dig into the critical lessons. If you love true crime, the story itself is gripping.
But if you're even thinking about a career in law, especially aiming for the bar, honestly, you need to know this case. It's practically required reading.
Okay, let's unpack this, starting with the incident itself. What actually happened that night?
Right, so let's paint the picture. It's Coffs Harbour, a coastal town. We're talking early hours, maybe 3 a.m., May 22nd, 1997.
Okay.
Raymond Ray Forbes, a local guy. He's had a good night, just left the RSL club, apparently won about $210 on the pokies.
Nice little win.
Yeah, so he's got that cash, plus maybe another $150 or so he already had in his wallet. And he heads over to Penguin's nightclub nearby.
And that's where he runs into Hunter and Sarah.
Exactly. He encounters 28-year-old Troy Torres, Sarah, and the younger one, 22-year-old Matthew Hunter. They're chatting, maybe having a final drink. Seems okay at first.
Until the bet.
Until the bet. As last drinks are called, Forbes, maybe feeling a bit flush from his win, jokingly bets $20 he can talk the bartender into serving one more round.
And Sarah takes him up on it?
Yep. Sarah says, okay, bet's on.
But the bartender obviously says no. It's closing time.
Of course. Security quickly ushers the three of them out onto the street. And that $20 bet, it's just left hanging there, unresolved.
And this is where things turn nasty.
Instantly. They're in this narrow alley behind the club, and Sarah suddenly insists on getting that $20. Forbes tries to laugh it off, like, come on, mate, it was just a joke.
But Sarah wasn't joking anymore.
Not at all. His whole demeanor changed, became dead serious, demanding the money.
So Forbes, maybe just wanting to avoid a bigger drama, starts pulling out his wallet.
And boom. Sarah just knocks the wallet straight out of his hand onto the ground and follows it up immediately with a really fierce punch to Forbes' head.
Wow. Okay, so it escalates really fast.
Incredibly fast. Forbes naturally throws his arms up, trying to shield his head. And in that moment of violence and chaos covering up, he feels more blows coming down.
From both of them.
Well, this is crucial. He sensed, but he couldn't clearly see Matthew Hunter joining in, maybe hitting him from behind.
He sensed it, but wasn't sure.
Exactly. He testified later that as he was covering up, getting hit from different angles in the dark, he sensed Hunter striking him, but he couldn't be certain. He never got a clear look at precisely what Hunter was doing.
And that uncertainty about Hunter's specific actions, that sounds like it's going to be really important later on.
Hugely important. So Forbes gets knocked down to the pavement, curls up trying to protect himself while the blows keep coming. He hears them swearing at him.
That it just stops.
Just as suddenly, the beating stops. Forbes, probably dazed and definitely hurt, sees the shapes of two men running off across the Pacific Highway.
He must have been in shock, Bleeding, wallet gone.
Yeah, he fumbles around his wallet with the winnings, maybe $150 cash, gone. He's even missing one boot that came off in the struggle. He starts trying to get towards the highway, toward the Coffs Harbor Hotel, seeking safety.
But it wasn't quite over yet.
Not quite. He looks back, and he sees Hunter coming after him again, still yelling something. So Forbes just bolts, runs down the highway. Hunter chases him for a bit, but eventually gives up near the hotel.
And Forbes sees them meet up again.
Yeah, he watches from a distance as Sarah and Hunter regroup near the entrance of a dark pedestrian mall, and then they just disappear into the shadows.
So shaken, bleeding, he finally goes back to the nightclub to get help.
Right. And police arrive pretty quickly. Senior Constable O'Mahony and his partner get there around 2:40 a.m. Forbes is frantic, injured. A security guard, Mr. Todd, had heard shouting and already called them.
And then they get a lucky break.
The huge break. A taxi driver, John Arkin, comes up to them. Says he just picked up two guys matching the description near the club, dropped them off at a house nearby.
Okay.
And here's the kicker. The fare was $15.80. But the guy with short hair matching Sarah's description pays with a $20 note and tells Arkin, keep the change.
Whoa, okay. Paying a small fare with a 20 and being casual about change right after a robbery where cash was stolen, that's more than suspicious.
It screams sudden influx of cash, doesn't it? It definitely pinged the officer's radar.
So they act on the tip straight away.
Immediately. 3 officers head to the address Arkin gave them. It's still dark, maybe 3:00 a.m. Senior Constable O'Mahony sees a light on in the kitchen.
He looks it in.
Yeah, peers through a window.
Yeah.
And there they are, Hunter and Sarah. And they appear to be counting money out on the kitchen bench.
Unbelievable. And did he hear anything?
He did. As Sarah walked out of the room, O'Mahony clearly overheard him say, "That's paid for the cab and our night out."
Wow. Okay, that's pretty direct evidence linking the money to the night's events, including the cab ride they just took.
It's incredibly strong. So the officers knock on the door loudly.
And inside, panic.
Looks like it. Startled, Hunter grabs the pile of cash off the counter, shoves it into his pocket, and O'Mahony sees this whole furtive movement in the beam of his flashlight through the window or doorway.
So they go in and arrest them.
Yep. Sarah and Hunter are placed under arrest right there on suspicion of robbery. And a search turns up wads of cash. Sarah has $180 on him.
And Hunter, the one who grabbed the money.
Hunter had $240. So between them, a total of $420.
Which is suspiciously close to what Forbes might have had his $210 winnings plus the $150 or so he started with. Maybe a bit spent. It fits.
It certainly raised eyebrows. And then later that morning, as dawn broke, a passerby found Forbes' wallet discarded in a gutter near the scene. Empty, of course.
The pieces seem to be falling into place for the police. Assault, missing wallet, suspects found with cash, incriminating statements, furtive actions.
It looked like a pretty clear-cut case at that point.
But the accused denied it.
From the very beginning, both men denied any wrongdoing. Hunter, in particular, was apparently quite vehement, protesting his innocence.
What was his story?
He told police he thought he was just breaking up a fight between Sarah and Forbes, that he wasn't involved in any robbery, and he only chased Forbes away to stop the whole altercation from continuing.
And Sarah?
Sarah apparently offered very little explanation, just belligerence. Reports say he was aggressive at the station, hurled abuse at the officers, didn't really engage with the allegations.
So, despite the denials, given the evidence collected,
they were both charged. Robbery with corporal violence under Section 95 of the Crimes Act 1900 for New South Wales. A really serious charge.
Carrying how much time?
Maximum of 20 years imprisonment. So the stakes were incredibly high as is headed towards trial.
Okay, before we get to the trial itself, let's quickly recap the legal steps leading up to it, because things were already getting complicated even then.
That's right. So immediately after the arrest, it's a police matter. No lawyers formally involved for Hunter and Sarah at that exact moment.
Then there's the committal hearing.
Yeah, on June 5th, 1997. Just a few weeks later. It seems it was a paper committal, meaning the magistrate just reviewed the written police brief of evidence to decide if there was enough to go to trial rather than hearing live witnesses.
And even then, were there signs of separate lawyers?
There were. Around June 20th, there's correspondence noted with solicitors in Brisbane acting for Sarah about his medical history. So Sarah, at least initially, had his own legal team involved.
And
his side was active too. On June 21st, whoever was advising Hunter, likely a solicitor by then, actually applied to the DPP, the prosecution, for a no bill.
Asking them to drop the charges against Hunter.
Exactly. Arguing there wasn't enough evidence specifically linking him to the robbery. They even suggested maybe reducing the charge against Sarah.
That's significant. It shows Hunter's team saw the difference in their positions right from the start.
Absolutely. They were trying to separate Hunter from Sarah legally, but the DPP rejected the application, so the charges against both proceeded.
So, separate legal activity early on, but then something changed.
It seems so, because by October 30th, we have a record of a conference where both Hunter and Sarah met with the barrister who would eventually represent them both at trial.
It's a single barrister.
The single barrister. They discussed the police brief, plan, strategy, and crucially, arrangements were made then to get those character references for Hunter, which were, in fact, obtained.
So this one lawyer is now acting for both, and he knows about Hunter's character references well before trial.
Correct. And then in November, the same barrister sends letters to both Hunter and Sarah with draft evidence statements and a fee estimate. An estimate based on the trial lasting 1 day.
1 day. For a serious robbery trial with 2 defendants, that sounds wildly optimistic.
Understatement of the year, maybe? It really suggests, looking back, a concerning lack of appreciation for the complexity and seriousness of the case. It ended up running for 5 days.
Anything else before trial?
Just a couple of procedural things. In
Yeah.
December, Sarah had that unrelated indecent assault charge formally severed, so it wouldn't prejudice this trial. Standard stuff. And the barrister apparently did some legwork, visited the arrest location, asked some questions around town.
Okay, so despite the early signs pointing towards separate defenses, they somehow ended up going into this very serious trial with one barrister who perhaps wasn't fully prepared for what was ahead.
That seemed to be exactly what happened, and it set the stage for, well, a legal train wreck.
Which brings us squarely to part 2, the trial itself.
Right. February 1998, the Coffs Harbour District Court. What should have been a standard criminal trial turns into something else entirely.
Presiding is Judge Twig, DCJ. His job is to ensure fairness.
And the prosecution, represented by a Crown prosecutor from the DPP's office. Their case seems pretty straightforward on the surface.
How so?
They've got Forbes' testimony about the attack, the bet, the money. They've got the taxi driver, Arkin, confirming the ride, the payment, and crucially, hearing Sarah say, "I hit him."
Which implies Sarah was admitting assault, at least.
Right. They've got the police evidence finding Hunter and Sarah soon after with the cash, Sarah's overheard comment, Hunter's front pocketing of the money. The Crown's argument is clear. This was a joint criminal enterprise. They acted together, intended to rob Forbes, so both are guilty.
Okay, that's the Crown's case. Now, the defense. This is where it gets messy.
Deeply messy. As we've established, one barrister representing both Matthew Hunter and Troy Sarah. This joint representation in a case with potentially conflicting interests, that's the first massive red flag.
Let's quickly paint a picture of the main players in that courtroom. The dramatis personae, if you will.
Okay. First, Matthew John Hunter. He's the younger one, 22. Comes from a tough background, apparently, but has people supporting him. Employers, family.
And his position is?
Consistent. I wasn't part of any robbery plan. I didn't demand money, didn't intend to steal. I just got involved trying to break up the fight. He has no serious criminal record. People describe him as generally honest, helpful.
And he has those character references ready.
He does. A whole portfolio described later as glowing from various people attesting to his good character. Evidence that, bizarrely, the jury would never hear.
Okay. Then there's Troy Gordon, Sarah.
Older guy, 28. Seems clearly the one who instigated the bet, and according to Forbes, the one who threw the first punch. Described as having a bit of a temper, brash maybe. His behavior with police afterwards was aggressive.
And his background.
Not as clean as Hunter's. He had a prior criminal history. Plus, that unrelated indecent assault charge was hanging over him, even though it was severed from this trial. So, a very different profile from Hunter.
Then the judge, Twig DCJ.
His role was oversight. Later critiques focused on things he perhaps should have directed the jury on, especially given the defense's issues, but no one suggested he was biased. He's relying on the lawyers to raise the right points.
The Crown prosecutor. Nameless in the reports, but their strategy is clear. Paint them both with the same brush. Joint enterprise.
Exactly. And then the defense counsel, the single barrister.
Let's recap his situation.
Former detective sergeant, so he knows courts from that side. Probably around 50. But, and this is critical, startlingly inexperienced as a barrister in serious crime. Mostly practiced employment law.
Not robbery with violence.
Definitely not. He'd only ever been a junior counsel in a handful of minor cases. This Coffs Harbour trial. His first time acting as lead counsel, solo, in a district court criminal trial.
Defending 2 men facing 20 years. His first solo lead.
Yes. And he himself later, quite candidly, admitted under oath during the appeal that the case just overwhelmed him. He said, quote, "By the time this trial was over, I was quite certain I wouldn't do another one."
Wow. He knew he was out of his depth.
It certainly sounds like it,
Yep.
which makes the decision to represent both men even more questionable.
And finally, the jury, 12 local citizens.
Their job: decide if Hunter and Sarah were both in on a robbery, or if maybe one was the main player and the other was just caught up, a bystander, maybe guilty of assault but not robbery. That crucial distinction.
But the way the defense was run made it hard for them to see that distinction.
Completely. This joint defense strategy just started falling apart from day one. Because the single lawyer treated them as a unit, the core defense was just both plead not guilty, both deny robbing Forbes.
Even though their individual stories were quite different.
Fundamentally different. Hunter saying, "I wasn't involved in the bet or the demand, didn't intend to steal, just intervened in a fight."
Whereas Sarah, well, the evidence points to him throwing punches over the money. His best defense might have been admitting assault, maybe claiming it was a drunken dispute over the bet that got out of hand, but denying any premeditated plan with Hunter to rob Forbes.
Exactly. These are distinct positions, potentially conflicting. One is saying, "I wasn't part of the robbery at all." The other might be implicitly saying, "It was a fight over money I started, but not a planned robbery with him."
But the barrister didn't see it that way.
Unbelievably, no. He later testified he saw no potential conflict of interest and no difference between their cases at that time, a judgment the appeal court called disastrously wrong.
Even the trial judge noticed the difference.
Judge Twigg himself later remarked it was obvious they had distinct cases. He pointed out Hunter had nothing to do with the initial bet, only got involved later, whereas Sarah was right in it from the start over the money.
So by merging their defenses, the lawyer glossed over this real difference in how blameworthy they might be.
Completely. He risked Hunter's arguably stronger position, the possibility he wasn't involved in the robbery intent being dragged down by Sarah's weaker position, where the evidence of aggression over money was much clearer. It was like trying to fit two differently shaped pegs into one round hole.
How did this play out when witnesses testified, like Forbes, the victim?
Forbes gave his account of the ordeal. But under cross-examination by the defense lawyer, he did concede he couldn't be absolutely sure Hunter ever actually hit him in the confusion.
That sounds like a huge point for Hunter.
It should have been. The victim himself expressing doubt about Hunter's physical involvement in the attack. A lawyer focused only on Hunter would have seized that, hammered it home to the jury, reasoned out right here from the victim's own mouth about Mr. Hunter.
But that didn't happen.
Not with the force it needed, because the lawyer was juggling both clients. Me and the taxi driver, Arkin.
What did he say again?
His testimony, under questioning from the defense, confirmed it was Sarah, not Hunter, who bragged, "I hit him in the cab on the way home."
Another point separating them. Sarah's admitting assault, Hunter isn't.
Precisely. It directly implicated Sarah in the violence, while suggesting Hunter hadn't made any such claim. It highlighted the difference in their actions and words after the incident. This is actually one moment where the defense questioning worked.
But again, the overall strategy didn't capitalize on it.
No. A competent defense, maybe with separate lawyers, would have used these points, Forbes' uncertainty about Hunter, Sarah's admission in the cab, to argue forcefully. Ladies and gentlemen, even if you think Mr. Sarah is guilty of something, the evidence against Mr. Hunter for robbery just isn't there. You must acquit Hunter.
But with one lawyer trying to defend both, that argument wasn't really made.
It got lost. The strategy remained focused on a joint acquittal, blurring the crucial distinctions that could have helped Hunter significantly.
And this carried through to the end of the trial.
Right into the closing arguments. The single defense counsel basically spoke for both men together, barely differentiating their cases or the evidence against them.
And he made that major mistake in his closing.
Oh yes, a huge no-no. He started talking about the potential penalties, the prison time Hunter and Sarah faced if convicted, basically asking the jury to think about the consequences, which is an improper appeal for sympathy.
And the prosecutor objected immediately.
Instantly. And Judge Twigg had to step in and tell the jury, "You must ignore those remarks completely. Punishment is not your concern."
That couldn't have helped the defense's credibility.
Probably damaged it significantly. The lawyer later admitted he just got carried away. It showed inexperience and poor judgment under pressure.
Interestingly, the jury seemed to pick up on Sarah being different, didn't they? With those odd questions.
Yeah, during deliberations, they sent out notes asking things like, did Sarah think Forbes was gay? Or was Sarah on drugs that night? totally irrelevant and speculative questions.
But it suggests they were seeing Sarah as maybe more volatile or unpredictable.
Possibly. It hints they were maybe grappling with his actions and motivations separately. But critically, the defense counsel didn't do anything about these questions.
He didn't object or ask the judge to redirect them?
Nope. Another missed chance to focus the jury on the actual evidence and the legal elements of robbery, particularly the differences between Hunter and Sarah. Instead, as the appeal court said, the jury was left to speculate along inappropriate lines, which could have unfairly harmed both defendants.
So this wasn't just one slip-up. The appeal court later called it a litany of errors.
A whole cascade of failings. And maybe the most damaging, especially for Hunter, was the failure to use his good character evidence.
Let's go back to that. He had this portfolio of references.
Yes, glowing letters from employers, family, community members, all saying he was honest, reliable, not violent. His mother, stepfather, partner, his boss, they were all apparently ready to come to court and testify for him.
And the jury heard nothing.
Zero. Not a word. The defense barrister made the decision not to call those witnesses or submit the letters.
Why on earth not? That sounds like exactly the kind of evidence Hunter needed.
His explanation later was that he thought it was too dangerous. Because years earlier, Hunter had been involved in some minor incident intervening in a street fight to help someone apparently didn't lead to a conviction. But the lawyer worried the prosecution might bring that up to argue Hunter wasn't so peaceable after all.
That sounds like a huge gamble, withholding strong positive evidence because of a minor, potentially inadmissible prior incident.
The Court of Criminal Appeal absolutely slammed that reasoning. They called the decision erroneous and unreasonable. They said a competent lawyer could have dealt with the prior incident, but the failure to present the positive character evidence, which they called impressive and persuasive, deprived Hunter of a key part of his defense. It denied the jury crucial information that could have made them doubt he'd participate in a violent robbery.
Wow. Okay, what else was in this litany?
Another huge one. Failing to argue for separate consideration or alternative verdicts. Yeah. Meaning, the lawyer didn't ask the judge to specifically tell the jury, you must consider the case against Mr. Hunter separately from the case against Mr. Sarah. And even if you find Mr. Sarah guilty of robbery, you need to decide if Mr. Hunter's also guilty of robbery, or perhaps guilty of a lesser crime like assault, or not guilty at all.
But the lawyer saw it as all or nothing for Hunter.
That's what he admitted later. Either Hunter was in on the robbery or he was totally innocent. No middle ground presented. This forced the jury into that terrible binary choice. Convict both of robbery or acquit both.
And with the evidence stronger against Sarah for the initial violence,
It practically guaranteed Hunter would get swept along. Failing to push for those separate instructions and potential lesser verdicts for Hunter was another massive oversight. A competent lawyer focused solely on Hunter would have been screaming for those directions.
were there other mistakes, like in questioning witnesses?
Yes, even his cross-examination tactics backfired. He tried to establish that Hunter and Sarah were too drunk to form the specific intent needed for robbery. So he questioned the police officers about how drunk the men seemed.
And the officers said,
They basically said the men seemed pretty aware, maybe had been drinking, but were coherent and deliberate. The questions produced the wrong answers, as the lawyer himself later admitted, and actually undermined the intoxication defense.
So summing up the trial performance, joint representation conflict, failing to differentiate defenses, withholding crucial character evidence, not seeking proper jury directions on separation or lesser verdicts, botched cross-examinations, improper closing argument.
It's a catalog of errors. The Court of Criminal Appeal didn't mince words. They said the defense case was very poorly conducted, and that the cumulative effect left the jury with a most unfavorable impression of the defense, making a fair assessment, especially of Hunter's individual situation, incredibly difficult.
So after these 5 days, the jury goes out. We know they had those odd questions about Sarah.
Suggesting they were maybe focusing on his role, his behavior. But in the end, given the flawed defense and the lack of clear options presented to them,
They came back with guilty verdicts for both.
yes, guilty verdicts for both Matthew Hunter and Troy Sarah on the single count of robbery with violence. The flawed joint defense led to a joint conviction.
Then it moves to sentencing. And finally, someone steps in regarding the representation.
Yes, thankfully. Here, at least, the conflict of interest seems to have been recognized, although very late in the day. For the sentencing hearing, Hunter and Sarah did have separate legal representation.
So new lawyers came in just for sentencing?
It appears so. The court record specifically says they were separately represented during the sentencing proceedings. This likely involved the firms that later handled their appeals stepping in.
Okay, who were they again?
For Hunter, it was Hamilton Quinlan Fenwick, and for Sarah, Fishburne Watson O'Brien. These solicitors likely took over at sentencing and then continued through the appeal process.
And with separate lawyers, the sentencing could focus on their individual circumstances.
Exactly. Hunter, younger, no serious record. Those positive community reports finally getting mentioned. He received a lighter sentence. Minimum 12 months, additional 12 months possible. So a 2-year total sentence.
And Sarah, older, prior convictions seen as the main instigator?
He got a harsher sentence. Minimum 18 months, additional 18 months. A 3-year total term. The judge clearly saw Sarah as the principal offender.
And the irony of the character evidence.
It's just painful, isn't it? At sentencing, character witnesses were called for both men. The exact kind of evidence that the trial lawyer decided was too dangerous to show the jury deciding guilt was presented to the judge deciding punishment.
If the jury had heard that evidence about Hunter,
Who knows? It might have swayed them. He might never have been convicted of robbery at all. It's a really bitter what if.
So, sentences handed down in February 1998. Hunter and Sarah are sent to prison, but the story wasn't over.
Not by a long shot. Almost immediately, there was serious discontent about how the trial had been run. Hunter's family and supporters were outraged. They felt his side of the story, his character, his lesser involvement, just hadn't been properly put forward.
And even legal observers were talking about it.
Whispers started circulating that the defense had been, well, a shambles, a total mess.
So they decided to appeal.
Both men lodged appeals against their convictions and sentences very quickly. And the main ground, the big...
For incompetence of their trial counsel.
Exactly. Arguing that the lawyer's performance was so poor it deprived them of a fair trial and caused a miscarriage of justice. That's a high bar to clear. But given the catalog of errors, they had a strong case to make.
And they got bail while waiting for the appeal.
They did. Hunter was released on bail in June 1998, Sarah in July 1998. So after only a few months actually inside, they were out, waiting for the Court of Criminal Appeal to review everything.
The whole focus now shifts, doesn't it? From the crime in the alley to the justice process itself, the spotlight is firmly on the defense lawyer's conduct.
Precisely. The stage was set for a really intense examination of the trial and whether justice had truly been done.
Which brings us to the appeal hearing, September 16, 1998, in the New South Wales Court of Criminal Appeal in Sydney.
And this wasn't just a standard appeal looking at points of law. It felt more like a trial of the trial.
How so?
Because the appellant's new legal teams were essentially putting the original trial lawyer's performance on trial. They were meticulously dissecting every decision, every error, every omission made by the defense counsel to show the judges that the convictions were fundamentally unsafe.
Let's look at the new cast of characters for this appeal. The judges first.
A panel of 3 very experienced judges. Meager J.A., Wood C.J. at C.L., and Dunford J.
Meager J.A.
Known for being incredibly sharp, legally brilliant. He agreed entirely that a miscarriage had occurred, but didn't write the main judgment.
Wood C.J. at C.L., he was the presiding judge.
Yes, and he wrote the crucial lead judgment that became the landmark decision. Hugely respected in criminal law, had even led a major royal commission into police corruption. Seen as someone deeply committed to justice, and his judgment would systematically tear down the trial defense. And Dunford J., the third member, fully agreed with Wood C.J., so it was a unanimous decision from a very strong bench.
Now the lawyers for the appeal, representing Hunter.
This is significant. Hunter was now represented by Mr. Philip Belanto, QC, a Queen's Counsel, a top-tier senior barrister assisted by junior counsel Mr. Woods.
Bringing in a QC suggests they were taking this very seriously.
Absolutely. Belanto QC was a formidable defense barrister. His job was to comb through the trial record and persuade the appeal court that Hunter's conviction was unsafe and unsatisfactory, precisely because the trial was mishandled so badly.
And Sarah's lawyer on appeal,
Mr. D.J. Murray. He focused on the same core issue, the trial counsel's incompetence. His argument was that even if the evidence against Sarah seemed stronger, the process was so flawed that Sarah also deserved a new, fair trial.
And the Crown, who argued against the appeal.
Mr. Marion appeared for the Crown. His role was to defend the original convictions. He argued that, yes, maybe there were some slip-ups by the defense, but the evidence of guilt, especially for Sarah, was so overwhelming that the errors didn't actually cause a miscarriage. The outcome would have been the same anyway, he argued.
And the solicitors behind them?
Still the same ones who likely came in at sentencing. Hamilton Quinlan Fenwick for Hunter, Fishburne Watson O'Brien for Sarah. and the Crown Solicitor's Office, specifically Mr. S.E. O'Connor instructing Mr. Marion.
And these solicitors gathered new evidence for the appeal.
Crucially, yes, they obtained affidavits, sworn statements, from pretty much everyone involved in the original trial. Hunter, Sarah, the Crown Prosecutor, the solicitor who instructed the trial barrister, and most importantly, the trial barrister himself.
So the original defense lawyer had to give a sworn statement about his own conduct and could be questioned on it.
Exactly. It's quite unusual for an appeal to delve so deeply into the lawyer's own testimony about their trial performance. But these affidavits, and the potential for cross-examination on them during the appeal hearing, were key. It allowed the appeal judges to understand why certain decisions were made directly from the lawyer and get the full picture of what went wrong.
So the core question for the appeal court boils down to, was the defense so bad it caused a miscarriage of justice?
That's the heart of it. They looked at Section 6(1) of the Criminal Appeal Act. It allows a conviction to be quashed if there was a miscarriage of justice on any ground whatsoever. Ineffective lawyering isn't listed specifically, but it definitely falls under that broad umbrella if it makes the trial fundamentally unfair.
And Wood CJ at CL laid out all the errors again in his judgment.
Systematically. The failure to get separate lawyers despite the conflict, the failure to see the different defenses, the inexplicable failure on the character evidence for Hunter, not objecting to the jury's weird questions, and just generally, failing to meet basic standards of advocacy you'd expect in a serious trial.
And they considered the trial lawyer's own testimony from the appeal hearing.
They did. His candid admissions about it being his first solo trial, being overwhelmed, deciding never to do another one, it spoke volumes. He tried to justify the joint representation, saying he didn't see a conflict then, but he did concede in the appeal that, looking back, yes, the jury could have returned different verdicts for each, which basically acknowledges the conflict he missed.
The court seemed particularly critical of the joint representation itself.
They called it a particularly egregious error. They emphasized that acting for both men when their interests were so different put the lawyer in an ethically impossible spot. His duty to one client clashed with his duty to the other.
Like with the character evidence.
Exactly. Arguing Hunter's good character would inevitably contrast with Sarah's priors and actions, potentially harming Sarah's case. The lawyer's loyalty was completely divided.
And the court found the clients weren't properly warned about this.
No evidence they were. It wasn't like they were fully informed of the risks of joint representation and consented. The issue seems to have just been ignored or glossed over, which the court saw as a serious failure of the lawyer's duty.
The omission of Hunter's character evidence really stands out.
It clearly troubled Justice Wood deeply. The appeal court had the actual references, that portfolio of impressive testimonials. They found the decision not to use them wasn't just a mistake. It was an unreasonable decision with no sound practical justification.
They genuinely thought it could have changed the verdict for Hunter.
Yes. Justice Wood basically said, if the jury had heard from all these respectable people vouching for Hunter's character, might they have had a reasonable doubt about him joining a violent robbery? He thought yes. Good character evidence can create doubt, especially for someone claiming they were just trying to stop a fight.
The court felt leaving it out was a glaring error, especially since the references were ready to go before trial.
Did the court look at other similar cases? Precedents? Definitely. They drew heavily on the principles set out in earlier cases. R.V. Burks from 1990 was key.
That's the one about flagrant incompetence.
That's the one, where the lawyer basically forgot to cross-examine on crucial points. Burks established that while courts usually defer to counsel's decisions in rare cases of flagrant incompetence that make the trial unfair, the appeal court must intervene to prevent a miscarriage of justice.
So Hunter and Sarah confirmed that principle.
Yes, and clarified there's no single test. It's always fact-specific. Do the errors likely affect the outcome? Were they serious enough to undermine the fairness of the trial?
Were there other cases mentioned?
They touched on R.V. Answer from the UK, which also suggested flagrantly incompetent advocacy could void a conviction, and R.V. Hamilton from 1993.
The one specifically about character evidence?
Right. Hamilton had criticized failing to use available character evidence, calling it vital. This directly backed up the court's view on the Hunter character evidence omission. They also cited an unreported case, RVD from 1996, as another example where they'd intervened due to lawyer errors.
So all these cases together built the argument that incompetence can equal a miscarriage of justice.
Exactly. It's not just about labeling the lawyer incompetent. It's about whether that incompetence fundamentally tainted the trial and likely affected the verdict. As the High Court later put it in another case, TKWJVR, the focus is on the effect of the errors on the trial's outcome.
And in Hunter and Sarah, the Court of Criminal Appeal decided the errors did have that effect.
Unanimously, they found the combined impact of all the mistakes created a significant possibility that the jury's verdicts, especially for Hunter, weren't reliable. The trial process itself was just too flawed.
So the judgment comes down on March 11th, 1999. What was the final verdict from the appeal court?
They allowed both appeals, found a miscarriage of justice had occurred for both Hunter and Sarah due to the defense counsel's errors.
But the outcomes were different for each man.
Critically different. For Matthew Hunter, the court quashed his conviction and entered a verdict of acquittal.
Acquittal, so not just a retrial, but completely cleared.
Completely cleared. Hunter walked free. The court decided that given the shaky evidence against him, specifically on the robbery charge, Forbes's uncertainty, the lack of a proper defense presented for him, no reasonable jury, if they'd had a fair trial with competent lawyering and proper directions, would necessarily have convicted him. The case against him just wasn't strong enough to warrant putting him through it again after such a flawed first attempt.
So after almost 2 years, he was exonerated.
Yes, a huge outcome for him.
And Troy, Sarah, his conviction was also quashed.
But for Sarah, the court ordered a new trial.
Why the difference?
Because while his trial was equally unfair due to the same defense failings, the actual evidence pointing to Sarah's involvement initiating the bet, throwing the first punch, the comment in the cab was considered much stronger. The court felt that a properly run trial, with a competent lawyer focusing solely on Sarah's defense, could still potentially lead to a conviction.
So the process was unfair, but the evidence against him might still stack up in a fair fight.
That was the court's view. They weren't prepared to acquit him outright. The first trial was too flawed to stand, so he deserved a second chance with a fair procedure. The DPP then had the choice whether to actually proceed with a new trial against Sarah.
Do we know if they did retry him?
The judgment doesn't say, and the original source material speculates the outcome is unknown. Perhaps a plea bargain was reached later on a lesser charge, or maybe the DPP decided not to proceed. We don't know for sure from this record.
And the trial barrister, the one whose performance was at the center of all this.
Well, the court, following professional custom, didn't actually name him in the published judgment, but the critique. Absolutely unsparing.
Justice Wood's judgment laid it all out.
Oh, yeah. It meticulously cataloged the litany of serious errors and lamented how those mistakes had fundamentally undermined the administration of justice in that specific trial.
So the judgment itself became a public rebuke.
Effectively, yes. It stands as a case study in how not to conduct a serious criminal defense, especially with co-accused. And remember his own testimony swearing off doing another jury trial. That spoke volumes about his own recognition of the disaster.
Did he face any formal discipline?
There's no public record of the Bar Association taking formal action based on this case, but the impact on his reputation within the legal profession would have been immense. Having a published judgment dissecting your failures like that, it's something no barrister ever wants. It likely sparked serious conversations about mentorship and ensuring inexperienced barristers aren't thrown into cases they can't handle.
This case clearly has huge implications beyond just Hunter and Sarah. It's become a real landmark.
Absolutely. It's a stark, powerful reminder that the right to a fair trial isn't just about the rules of evidence or the judge's conduct. It includes the right to competent legal representation. If the lawyer's performance sinks so low that it makes the verdict unreliable, the system has to step in.
And the biggest lesson seems to be about conflicts of interest, especially with co-accused.
That's probably lesson number one. Barristers have a strict duty to avoid conflicts. The rules are clear. If representing multiple accused could possibly prejudice any of them, you shouldn't do it. Or at the very least, you need fully informed, documented consent, which didn't happen here. Hunter and Sarah shows just how badly things can go wrong when that duty is breached. The lawyers simply couldn't advocate effectively for both men simultaneously.
It also hammers home the duty of competence, doesn't it?
For sure. Lawyers don't have to be perfect, nobody is. But there's a baseline standard. You need to be prepared, know the relevant law, understand the procedures, and have the necessary skills for the case you're taking on.
This barrister seemed to lack the specific experience for this kind of trial.
Yes. Despite his police background, he took on a serious, complex criminal trial. His first solo lead with insufficient barristerial experience in that area. He misjudged how long it would take, seemed unfamiliar with key legal concepts like joint criminal enterprise, failed to implement basic tactics like using character evidence.
So the message for aspiring barristers listening:
know your limits. Be honest with yourself about your experience level, Prepare like crazy for every single case. And crucially, don't be afraid to ask for help from a senior colleague, or even turn down a case if you feel you're out of your depth. That sense of "I have to soldier on" can lead to absolute disaster for your client and public embarrassment for you.
It also highlights the need for a proper defense strategy, right? Not just reacting.
Definitely. A good defense integrates everything: the facts, the law, the client's personal story and character. Here, the lawyer had potentially useful elements like Hunter's character and Forbes's uncertainty, but didn't weave them into separate, coherent strategies for each client. He gambled on a joint acquittal, and it backfired. The appeal court made it clear: each accused deserves their own case properly presented. One size does not fit all.
And communication with the clients seemed to break down too.
That's another key takeaway. Lawyers must communicate clearly with their clients about the strategy, the risks, the options. If you're advising a client to waive a potential conflict or not to use certain evidence, they need to understand why and what the consequences might be. It has to be an informed decision. Hunter, at least, seemed unaware his strong character evidence wasn't going to be used. That's a failure of communication. Always document those crucial conversations.
Ethically, it's a reminder that how you play the game matters.
Immensely. The goal is justice, achieved fairly. The Crown won the battle at trial but lost the war on appeal because the process was flawed. The defense lawyer lost the trial, but his failures inadvertently exposed systemic issues that needed correcting. The appeal judges weren't just being technical, they were upholding the integrity of the process itself.
So where does Hunter and Sarah sit now in Australian law?
It's a really important precedent, cited frequently alongside Burke's. It guides courts whenever an appellant claims their lawyer's incompetence led to an unfair trial. It confirms that the court will intervene in such cases, but it also sets a high standard you have to show, not just mistakes, but mistakes so serious they likely caused a miscarriage of justice.
Okay, let's quickly recap that procedural timeline again, focusing on who represented whom at each stage, just to consolidate it.
Right. So, May 97, the incident and arrest. Initially, just police involved.
Then June 97, the committal hearing. Seems it was just on the papers. But around this time, we know Sarah had Brisbane solicitors involved, and Hunter's side, presumably other solicitors, made that unsuccessful no-bill application. So separate legal advice early on.
Yes. But by October 97, both Hunter and Sarah are meeting with the single barrister who will ultimately conduct the trial. He gets briefed, plans for Hunter's character references. By November 97, he's sending them draft evidence and that optimistic one-day trial fee estimate.
December 97, Sarah's unrelated charge is severed. The barrister does some site visits.
Then February 4th to 9th, 1998, the 5-day district court trial before Judge Twigg DCJ. Prosecution is a Crown prosecutor from the DPP. Defense is that single, relatively inexperienced barrister instructed by a local solicitor who apparently just assisted on day one. Outcome: both convicted.
Immediately after conviction for the sentencing hearing later in February 98, separate representation kicks in. New lawyers, likely the ones who continue to appeal.
That's Hamilton, Quinlan, Fenwick, solicitors for Hunter, and Fishburne, Watson, O'Brien, solicitors for Sarah. Barristers aren't named for sentencing, but likely different ones instructed by these firms. Sentences: Hunter 2 years total, Sarah 3 years total.
Mid-1998. Appeals lodged. Affidavits gathered from everyone, including the trial barrister. Bail granted June-July 98.
September 16, 1998. Appeal hearing before the NSW Court of Criminal Appeal. Wood, CJ at CL, Meager, JA, Dunford, J. The Hunter, represented by Philip Belanto, QC, and Mr. Woods, instructed by Hamilton, Quinlan, Fenwick. Sarah, represented by Mr. DJ Murray, instructed by Fishburne, Watson, O'Brien. Crown, represented by Miss Marion, instructed by Mr. O'Connor from the DPP.
And finally, March 11th, 1999. Appeal judgment delivered. Hunter acquitted. Sarah granted a retrial.
That's the journey, from the alleyway to the appeal court, tracking the changing legal teams along the way.
It really is an incredible story. A true crime narrative, yes, but the real drama, the real thriller, unfolds in the legal system's response to its own potential failings.
It truly is. R.V. Hunter and Sarah isn't just about a robbery gone wrong. It became a story about the justice system's ability and duty to self-correct, and about the incredibly high standards of competence and ethics demanded of lawyers, especially barristers.
For the public, it's a peek behind the curtain, isn't it? Showing how justice can sometimes stumble, but also how mechanisms like the appeals process exist as a vital safety net. It reaffirms that everyone deserves a fair trial, and that includes having a lawyer who is actually capable of presenting their case properly.
And it underlines a core principle. Better that a guilty person might get a retrial or even go free if the evidence isn't there after a fair process than for a conviction obtained through an unfair trial to be allowed to stand.
And for any aspiring barristers listening, this case is drilled into you for a reason.
It's a stark object lesson.
Yeah.
Number one, be hyper-vigilant about conflicts of interest, especially with co-accused. If there's any chance their interests diverge, separate lawyers are almost always the safest, most ethical path.
Number 2, competence. Know your limits. Prepare fanatically. Get help if you need it. Don't be the barrister who soldiers on into disaster.
Number 3, strategy. Think holistically, differentiate between clients where necessary. And number 4, communicate clearly and honestly with your clients about the plan and the risks.
It all comes back to that image of the trial lawyer, the ex-detective turned barrister, thinking he could handle this complex case solo, representing both men, glossing over the details, and ending up with his failures laid bare in a published judgment.
A cautionary tale personified. His mistakes nearly cost 2 men years of their lives unjustly and became a permanent fixture in legal education.
So, the final thought maybe, justice isn't just about the verdict, it's about the process. Every single person in that system, police, lawyers, judges, jurors, has a role in keeping that process fair and reliable.
And when someone drops the ball, as happened here so significantly, the system has to be willing and able to pick it back up and ensure justice is ultimately done. Hunter and Sarah stands as that critical reference point, that reminder whenever the competence of legal representation is called into question.
A fascinating, complex, and ultimately very important case. Thanks for joining us on this deep dive.
Hope you found it insightful.
We'll see you next time.